Hello, friends. I welcome you all to this session of Indian Evidence Act. And today we are going to study three sections, which are a bunch in itself, and they relate to rules as to refreshing memory. We all know that cases take a long time, and some witnesses may tend to forget things. So, um, they may not recall actually what happened. So, there are certain sections, section 159, 160, and 161, which are related to refreshing the memory. Now, just a brief overview how to remember it. It's LRA, that is legal representative asked, or legal representative as advocate. So what 159 L stands for is look. That is, if a witness, for example, this is the witness and she says, I don't recall, or if she doesn't recall, then that witness may refer to any writing. So that is, or look at any writing. Though that writing either should be made at by herself at the time when the event took place or by the IO, or it or in case it is being given by an expert, suppose she is a professional, she is expert in that field, then she may even refer to book. Then r stands for refer to the document. Now suppose a document is in question, that whether this witness has to testify about the document. Now, witness may not remember all the thing which is written in that document, but witness may identify the document and say that yes, this is the document, or at the time when it was written, it was correct. So, one need not remember all the contents of the document, but may testify the document was correct. And 161, that gives a right to the adverse party, that if this lady refers or witness refers to some document, then this the opposite party also, or the adverse party, may also look on the document and cross examine her. So these are the three sections which deals with refreshing the memory. Now let us do one by one. Section 159, what it says: refreshing memory. A witness may, while under examination, refresh his memory by referring to any writing made by himself at the time of transaction concerning which he is questioned. So, any writing which was made by himself, or soon afterwards, that the court considers it likely the transaction was at that time fresh in his memory. So, writings which are made by himself. The witness may also refer to any such writing made by any other person and read by witness within the time aforesaid, if when he read it knew it to be correct. So the witness may refer to those writings which are not made by himself but by other person, but he knew it to be correct. Or when the witness may use copy of document to refresh memory. So in this case, if a copy of document is to be used for refreshing memory, then that may be the primary document or secondary document. But if secondary document is being given, then the court has to be satisfied as to why primary document is not being produced. An expert may refresh his memory by reference to professional treatise. So, section 159 basically provides that the witness may refresh his memory by writing made by himself, but that writing should be made at the time when it was still fresh in his mind. Or a writing which is made by any other person, but the witness knows it to be correct. Or any professional treatise where the witness is an expert. So, when a witness wants to refresh his memory by referring to a document, he may refer to a copy of it. But in that case, it should be the sufficient reason should be provided as to why the original of the document is not produced. It is, however, not necessary that document of writing used for refreshing memory should be relevant or admissible in evidence, but fact right to be proved must be admissible. What it says is that that particular document which is being referred to refresh memory, that document may not be relevant in that particular case. Only what needs to be proved through this document needs to be relevant. So that is what is section 159. Now what happens if the document itself is relevant? So in that case section 160 applies, and in section 160 the witness may say that yes, this document I correctly identify and whatever is written in it is correct. So basically section 160 is not necessary. Under 160 it is not necessary that a witness looking at written instrument should have a specific recollection of matters stated therein. He may not remember all the points which are mentioned in that document, but he may testify to the facts referred to in it if he recognizes the writing or signature and feels sure that the contents of documents were correctly recorded. So the witness may say that whatever is recorded in this statement was recorded correct and is correct, though he may not himself remember all the facts written in the document. So, under section 159, the document which is referred for refreshing memory is not in itself evidence, nor it is tendered in evidence. But under 160, the document which is referred is actually tendered in evidence. So, what this says, testimony to facts stated in documents. A witness may also testify to the fact mentioned in any such document, although he has no specific recollection of facts themselves, if he is sure that facts were correctly recorded in the document. So, an illustration is also added that a bookkeeper may testify to the facts recorded by him in the book, regularly kept in course of business, if he knows that the book were correctly kept, although he has forgotten the particular transactions entered in it. So, suppose there is a bookkeeper and he knows that there are entries, he will not remember the day to day entries made in it, but he knows that it is correctly kept. Then he says he can testify that yes, this document is correct. Next is section 161. Now 161 gives right to adverse party to use the writing which is used to refresh memory. Any writing referred to under the provisions of 159-160, that is to refresh memory, must be produced and shown to the adverse party if he requires it, and such party, if he pleases, cross-examine the witness thereupon. So, whatever document is used to refresh memory must be shown to the both the parties, and both the party may use, and the adverse party may use to cross-examine on it. So section 161 provides that any writing used in the section 159-160 used for the purpose of refreshing the memory of witness must be provided and shown to adverse party if he requires it, and such party may cross-examine the witness thereupon. So these are the three sections which are related to the refreshing of memory. That is section 159, which says that the witness may look into any writing made either by himself or by any other person, or an expert may look at any treatise. If a document itself is in question, he may refer that document to be true, though he may not have a specific recollection of it. And section 161 gives right to adverse party to look into those documents which are used for refreshing memory and cross-examine the witness on it. That's all. Thank you, friends.